There's a concept in U.S. copyright law called a work for hire, or as the Copyright Act actually calls it, a work made for hire. The idea is this: if an employee develops something within the scope of his or her employment that is subject to copyright protection, then the law doesn't consider the employee the author. It considers the employer the author of that work from the very beginning. That work, let's say it's a report, or perhaps it's software written in the scope of one's employment as a developer for a software company, that work is covered by copyright, and the company itself is considered the author and therefore the owner of the copyright that covers that work of authorship. Works for hire also apply to non-employees who are contractors. Perhaps I hire someone not as an employee but as an independent contractor to perform some kind of work. Perhaps I've commissioned a painting, or perhaps I've employed someone to write a report or some software code for me. It is not the case that that is automatically considered a work for hire. The Copyright Act requires that in order for the work product of that engagement to be considered a work made for hire, that it must be the subject of a written agreement between the parties, and that agreement must state that the parties intend for the work to be a work made for hire. And if those requirements are met, then from the moment that the work is first created, the party that hired the contractor is considered the author of that product and can claim the copyright bundle of rights in that work of authorship. That's a work made for hire. You'll often see in contracts that we have a belt and suspenders approach. We will say that all work product created in the course of an engagement for the company is considered a work made for hire. But in the event that it can't be considered a work made for hire, we require that the contractor actually assign or transfer to the hiring party, to the company, all of his or her rights in that product. It doesn't make the company the author, and the author automatically holds the copyright from the beginning, but he can sell that copyright to the party who hired him. So we often very carefully make sure that all that can be considered a work made for hire is in our contracts, and in addition to that, we require an assignment of any rights that the contractor happens to retain. Work made for hire.